Here we go. We're going live. Look at the camera, smile. Hello, I'm Diane Cohen with Macro Pro, and I'm here with Mark and Sid today. We are going to be doing yet another one of our 12 CEUs of Christmas. Gentlemen, how are you?
Doing great
today. Thank you.
Excellent. Excellent.
Great.
So this is our third CEU Christmas. I have not yet asked our attendees about anything Christmas related. So I'm going to ask the questions to our attendees, and then if you both would answer it, that would be fantastic. Do you have a favorite present in your childhood that you still remember to this day? And put it in the box that has a question mark on it, because that's where you're going to be addressing questions to Mark and Sid, should you have any. So while our audience is telling us about their favorite gifts, Mark, why don't you tell us what yours was?
Yeah, I got, when I was maybe 7, 8 years old, I was interested in basketball, but I was too small to reach a 10-foot rim. So this makeshift, and back then this was a big deal back in the late 70s, a makeshift hoop that was probably 6, 7 feet tall. So that started my basketball career until I didn't grow any further in high school.
I get it. So I don't see very many people typing it in. So please, audience, type yours in while Sid tells us, what was your favorite, Sid?
Yeah, so for me, I remember when I was a kid, the thing that excited me the most and the thing that still sticks with me is that I received a Nintendo when it came out back in the early 80s. And that was something that my parents really couldn't afford. But my aunt was kind enough to surprise me with the gift. And that's something that has always stuck with me. And you know, I always love and remember and cherish them. Thanks.
Yeah. So I'm seeing some answers here. A trip to the snow. Somebody loves the cash that they got. And then there's somebody who replied kind of sort of like part of my childhood. And they said they were too poor to have Christmas. So I remember getting my Salvation Army presents. So the fact that I'm living the way I do today is quite an accomplishment, and I'm so delighted that, you know, things have changed for me and my family. So Doris, I hope the same is true with you. And I see there's another one here, a remote control car. That would be kind of fun, isn't it? All right, I'm just gonna do a little bit of housekeeping, keep those things up. I'll look at those. Just as a reminder, today's class is worth 1 CEU unit. You should be getting that today. Your certificate today, please download it immediately. I have 30 days that I can assist you on that, and after that I can't. So make sure that you do look at that. There are handouts attached to this webinar, so make sure you go to the little paper clip up there at the top and download those so you can have Mark and Sid's brilliance in your office. If you have any questions, put it there where you're putting in your stories. That would be fantastic. And this is being recorded, so you'll be able to watch it on the YouTube channel at Macro Pro. In addition to that, TC is going to be on the line in the back asking questions. So any questions you have, make sure you put those in for the gentleman, and we'll be asking those at the end. So the floor is now yours. Thank you, gentlemen.
All right. Thank you very much, Diane, and good morning, good afternoon, everybody, depending on where you're sitting. And we're very excited to be back with the Macro Pro program. We love working with Macro Pro and Diane. And she really came up with a killer title here, Medicare Mayhem and Milestones. You know, what brewed in 2025 and what's ahead in 2026. So it's sort of a recap. So some of you may have been following closely the Medicare developments over the year. And for you, this will be more of a checklist. Make sure you got everything. And for others, maybe you had other stuff to do, more exciting than Medicare, and you're trying to catch up. And if that's the case, this is the ultimate cram session to impress your friends during the holiday season. There we are, we're on screen. Okay, today's agenda, a little bit of everything, a little bit of something for everyone. And we broke down the topics by numerical number. Now, some of the topics we'll spend more time on than others. So you may be sweating it out, saying these guys are never going to get done in certain areas, but we will, because some of the topics don't really warrant a ton of discussion at all. And we can go very heavy, very light there. Some of the other topics, the Section 111 penalties, the TPOC MSA reporting, they warrant a little bit more depth. So we'll spend more time there, but then others will require real cursory type reference just to make sure you're aware of it. All right, and here we go. So here's going to be the format. So you're going to see these numbers, the numerical topics. 1, Section 111, civil money penalties, CMPs, fines, penalties, whatever you want to call it. Okay, we've waited a long time for these, not that anybody wanted them, but CMS's long, cumbersome, slow, and sloppy implementation is over. And depending on how you're measuring, it either took CMS 3 years to put it together, 10 years to put it together, or 15. It's immaterial now because Section 111 penalties are live. Now, Sid and I built these at-a-glance slides for some of the sections where it's warranted. And the idea is, and Diane is making the resource available to you, the idea behind at-a-glance is to give you a summary before we get into the deeper material. So you won't see Sid and I really going through each bullet point here. Okay, this is more for you later because we're going to discuss it in depth beyond this. But in general, what the nutshell here, the at-a-glance is telling you is that the penalties as of October 11, 2025 are now live. And CMS is going to start their audits in January, which means that insurers or responsible reporting entities in the 111 space may start to see penalty notices as early as January. We don't know. CMS is going to start their audits there, right? So that's what the at-a-glance is about. So now let's take it a step deeper and kind of go into the various aspects of the civil money penalties, CMPs. To the left, when can CMS impose a penalty? When the RRE, the responsible reporting entity, insurer, self-insured, a self-insured risk entity, fails to report the TPOC report or the ORM report within 1 year. Now, CMS had a lot more draconian provisions on the table. Good news is they didn't finalize them. So the only basis for the penalty is if you fail to report your TPOC or ORM within 1 year. Okay, now, if you look, obviously, CMS says that, they're going to measure timeliness by a successful report. You just can't send them junk. They actually have to accept your filing. Okay, so you need to get this right. So make sure your full Section 111 report is correct so that it doesn't get rejected. Okay, so then the question from there becomes to the right, how will CMS measure timeliness? So for the TPOC, or settlements, judgments, awards, or other payments, right? They're going to compare the dates of the RRE's first successful report with either of the following. A, the TPOC date, or, if applicable, the funding delayed beyond TPOC start date field. So that's what they're going to do. That's how they're going to measure the 1 year. Did you get it in within the 1 year? ORM, ongoing responsibility for medical. Now, this is an idea that's very relevant in workers' comp, no-fault med pay, etc. In this situation, where you've accepted ongoing medical responsibility for medical, the claimant's a Medicare beneficiary, you have ORM, CMS will compare the date of the RRE's first successful report with the CMS date of incident, DOI, as reflected within the ORM coverage record. Now, the box below, what that's getting at is this. CMS uses the date of incident, DOI, as their default date for ORM. However, there could be instances where that's not really the true date of the ORM. It could be a subsequent date, but CMS's system only accepts the DOI. So CMS recognizes that there may be times where on their end, it may look like you're late on the ORM, but you're really not. So CMS says, hey, look, if that happens, when we give you an informal notice that we're thinking about penalizing you as part of the mitigation evidence process, which I'll discuss more in a minute, you need to tell us that. Now, would it have been a lot better if CMS just fixed their system to collect the true date of the ORM? Yeah, probably. They didn't do it. Okay, so that is what that bottom box is about. So this is how they're going to measure timeliness. Okay, so now, what's in scope? It's been a long, torturous rollout. So if we look in the big box in the middle, only coverage record submissions with the effective dates, the ORM or the TPOC dates of October 11, 2024 or later, are in scope for penalties. Okay, so now it gets really real, right? Because we are beyond that. October 11, 2025 up top, coverage records and scope for penalties may begin to be identified. How will they do that? To the right, up top, 111 randomized quarterly audits will begin in January. Okay, so now CMS is going to start to review records, okay, to see whether or not a person or an entity, a responsible reporting entity, RRE, could be in scope for penalties. So then the question becomes, well, how will they penalize the RRE? Well, they're going to do it in a tiered format. The longer you're late, the more you will pay. If you're 1 year to 2 years late, to the right, $368.50 a day. If you're 2 years to 3 years late, $737 a day. If you're 3 or more years late, $1,474 for each calendar day. Now, the numbers look wacky, and that's because they're adjusted annually for inflation. Now, the last annual inflationary update I could find, and I've been checking the regulation and my other sources for a while now, is August of 2024. So we're due for another inflationary increase. So probably in 2026 at some point, these numbers will be higher. The point of the screen is that you're going to be penalized in a tiered format, and they could add up. You can do the math, right? And look at the bottom, the max penalty for any single instance of non-compliance, like it's some bargain, is $538,000. So this could be significant. So this is why you need to be on top of this. All right, so now this screen becomes huge. We've been doing this screen a long time, but now it's real. In fact, we're going to have a brand new article out probably next week sometime on the random audit selections that start in January 2026. First to the left, CMS, as part of their audit process, will review 250 coverage records consisting of both non-group health plans and group health plans each quarter. And they're going to do it proportionally based on the number of records they receive between non-group health and group health. Now, folks, this could have been a lot worse, right? 250 is not necessarily a ton of records, right? But nonetheless, if your number's called, you could be, in trouble, right? You could have a problem. So this is why you can't be complacent. And if you look to the right, it's what I've been mentioning a couple times already. Next month, CMS starts their randomized selection of Section 111 audits. They're going to look at both Section 111 record submissions and non-Section 111 record submissions. So we don't know exactly how they're going to pick and choose. They haven't really mentioned that. CMS is having a webinar on January 15th. Maybe they'll tell us then, okay, on their penalties, January 15th. The important thing to understand here is that you will only be notified by CMS if they identify non-compliance. So they could have reviewed some of your records and you passed, but you'll never know that you were being audited. However, if they review your submissions and they identify a potential instance of non-compliance, then they're going to take a step further. They're going to notify you. How are they going to notify you? Here's the process. Number one, they're first going to give you what we could consider an advance notice, but it's really called informal notice, okay? They're going to come to you, hey, we're thinking about penalizing you. Now, importantly, look at the screen. You only have 30 days to submit mitigating evidence. Reasons why you should not be penalized. CMS said we're not going to give you time extensions, so you got to get your info in. Why? You're only going to have one opportunity to do this. CMS, yeah, we got your notice. You're thinking about penalizing us, but you shouldn't because of these reasons. Okay, that's mitigating evidence. And I gave you one example in the ORM example at the beginning. This is where you would address that with CMS. The trick is, as welcoming as CMS is about mitigating evidence, they want it. And if you read their rules, they say, man, we really don't want to penalize you, so get us mitigating evidence. As generous as they are there is as stingy as they are with the 30 days. Get it in within 30 days. So let's say you get it in and they're satisfied, hey, you're right, we shouldn't penalize you, it's over. However, you get the mitigating evidence in and they disagree with it, or you just blew off the 30 days and did nothing, then you're going to get a formal notice And that is called a notice of proposed determination in box 2. And this is where it gets formal. Okay, we're going to penalize you this amount for this reason, etc. At that point, you will have formal appeal rights. You can go to administrative law judge, the departmental appeals board, and ultimately into federal court. But here's the deal. When you are dealing with any of this stuff on this screen, mitigating evidence, formal notice, the right to appeal, timelines are going to be paramount. So read that correspondence carefully. You don't want to lose on a technicality like you didn't get your request in time for an ALJ hearing. Boy, what a way to lose, right? Okay, so what you want to take away from this screen is that you will get notice, you'll have opportunity to first challenge with mitigating evidence. If that doesn't work, it's going to get formal. You'll have these formal appeal rights, but timelines will be key. Okay. So let's say you did everything you could, you fought the good fight, you lost, or you just did nothing, you blew them off the entire way. Well, at some point, CMS is going to come looking for their money. And this is called the notice of final determination. This is their indication to you that their penalty is final. And this is going to be the notice to you that tells you that, number one, tells you how to remit your payment and where to send it to. Let's hope we don't deal with this screen. Okay, so that brings us to the conclusion of the penalty aspect. Now, remember, especially for the folks from the liability world, there is a compliance safe harbor. I mean, it applies across the board, but a lot of times what I'm about to talk about resonates loudly with liability insurers who have trouble getting the big 5 data elements. And we need the big 5 data elements to determine the claimant's Medicare status, right? And then from there, we could determine whether we have to report. But if we can't determine the Medicare status, then we got a problem, right? The real problem is when they passed the law, they didn't make it mandatory for the claimants to cooperate with the insurer on this, right? So what CMS basically says is this: look, if you make a good faith effort to get the big 5 data elements, first name, last name, date of birth, gender, social security number, or the Medicare beneficiary identifier number, MBI. Okay, if you make a good faith effort to get that stuff and you can't get it because of a lack of cooperation or outright refusal from the plaintiff or the lawyer, then if you document it properly, we will give you a safe harbor, a protection from the penalty. What you need to follow, though, is CMS's process to get that safe harbor. That's on the screen. You got to go out at least 3 times to both the claimant and his or her attorney or representative. Okay, it's an and. And you got to go once in writing, including electronic mail, and then at least once more by mail, and at least once more by phone or other means in the absence of a response to the mailings. Okay, so they're giving you the formula. It's a live link at the bottom if you want to look at the words in the regulation. Okay, and if at any point in your efforts to get to get the data points through your 3 efforts, the plaintiff or the lawyer tells you really to go stuff it, that they refuse to give it to you. If you get something there that clearly and unambiguously indicates they decline or refuse to give it to you, then you can stop asking for the information. No matter what you do here, you need to document your efforts to get the info and the responses you get back from the claimant and the lawyer. Okay, because that's what you're going to need to show as your evidence if you ever get in a pickle about a potential penalty on a file. Now, the next screen, a lot of people ask, hey, man, do I need to do these in the same order, Mark? You have them on 12. And CMS in a webinar says, no, we don't care what order you do them, just do them. Okay, and they say, look, you need to space out your requests to make sure, you're requesting it reasonably. And somebody asked, well, CMS said, look, man, if you did all 3 requests on the same day, we would consider that unreasonable. Okay, so you got to figure out how you want to space it out. Okay, the order does not matter to CMS. Okay, so Section 111 penalties, good faith safe harbor. Okay, Sid and I are always available to go further with you offline if you like. January gets real because that's when the audits are going to start. All right, Sid, we've also had action in the 111 world outside of the penalties, right? And a bunch of user guides were released. Tell us what's going on here.
Sure. Yeah. Thanks, Mark, and appreciate you walking us through the CMPs. We know that they're, not only live now, but Medicare is going to start auditing in 2026. So really something that we're keeping a close eye on. Now, with respect to Medicare and the release of their guidance through the Section 111 user guides, we did see a lot of activity, right? So on the left side, you can kind of see a consolidated list of the user guide releases from this year. I can say that, with respect to the one in January and the one in May, they're very similar in to the extent that that was to kind of reestablish or validate that the reporting thresholds for liability, no fault, and workers' compensation claims remain at $750. The one in May clarified the text a little bit to ensure that the industry was aware that it does not apply when you talk about that threshold, does not apply to those no fault and work comp claims where there is exposure, implantation, or ingestion involved, right? So that's not really a major change. It was just a clarification. Now, with respect to the one in April, that was a pretty significant update because as part of what Medicare did this year related to Section 111 reporting is they introduced, which we'll talk about a little bit later on in some more detail, they introduced a new reporting requirement for workers' compensation claims. So if you're settling a claim, right, we talked about TPOC earlier, if you're reporting that TPOC as part of Section 111 reporting for workers' compensation claims, you must now report Medicare set-aside data as part of that. So that update in April was to essentially memorialize and provide guidance from the technical perspective of that reporting requirement within the user guide. Now, the most recent user guide release, version 8.2, it's dated October, but it was actually released in November. This was a fairly significant update as well, so I'm going to spend a little more time on this one. But really, the major point of this particular update was now that finally Medicare has clarified how to report settlements when there's a single settlement resolving multiple incidents. And now we know Medicare expects one report, right? You're reporting the earliest date of incident across all the dates of incidents that may be resolving, as well as to include all the ICD codes that are being claimed in or released as part of that settlement as well. So our understanding is that this is, for us, this is guidance that Medicare has consistently provided, kind of informally in discussions and in inquiries with both Medicare and their contractors, but other folks may have received different guidance depending on who they spoke with. So for us, it's really no change, but this may have impacted those that may have heard or been instructed to handle this a little bit differently. Now, when we talk about Medicare set-asides, we now know that that is also required as part of work comp reporting. Medicare's position here is very similar. When you're dealing with multiple dates of incident, you're only reporting that Medicare set-aside data once. You report it with that single settlement report. You don't need to report for all the other incidents that are settling as part of that one settlement. Now, if you're dealing with multiple settlements involving the same individual, right? So this is distinguished in the sense that this isn't a single settlement with multiple incidents. This is different multiple settlements. And Medicare has really looked at situations where there's multiple responsible reporting entities. Their guidance here is that each responsible reporting entity, or RRE, is responsible to report their portion of that settlement, right? So you're not reporting it in the aggregate, you're reporting your portion of that settlement. Now, the other updates are a little bit more technical in nature. I'm not going to spend a ton of time on this, but one, they updated the claim input file processing time from 48 days to 33 days. They added a couple new change reason codes for the unsolicited response file. Again, very technical. Don't need to necessarily get into that right now, but if you have questions about it, let us know. Also, with respect to the MSA reporting data, there is the professional administration EIN number. And in relation to that, Medicare has introduced a new error code for it. It's the CW09, basically identifying where there's an incident where the professional there's an error in that number, and therefore to notify you to correct it. It's considered a soft error. It's not going to reject that particular report when you send it to Medicare, but it's something to flag for you. Also, there's the CW08 error, which is what we call a hard error. It will cause a rejection. It is tied to the case control number that Medicare is now collecting for MSAs, and essentially means that the information submitted doesn't match what Medicare has on file, and you need to correct it as well. All right, next slide, please. Okay, so shifting gears and diving more into that new MSA reporting requirement for workers' compensation claims. Let's take a look at the next slide, Mark, and we can kind of give a high-level overview, right? So for the first time, Medicare is actually collecting Medicare set-aside data and tying that into the mandatory Medicare reporting requirement. And this started April 4th of this year, and now requires responsible reporting entities to provide this Medicare set-aside information and the specific data points, which I'll talk about in a second. But really, this is a pretty significant shift, and it applies to all workers' compensation settlements involving a Medicare beneficiary. So what this gives Medicare is a really, significant view and insight into the use of workers' compensation Medicare set-asides in the settlement of workers' compensation claims. It allows them to better coordinate benefits and deny payment for treatment if there is an MSA in place to pay primary, and it allows Medicare a pathway to monitor and evaluate their MSA program and to potentially audit this information, down the road. Now, Medicare is going to be holding a webinar a little bit, I think a little bit later this year, or maybe in 2026. There was one scheduled for October 1st of this year, but because of that government shutdown, they did postpone it. All right, next slide, please. So here you can see on the right side the data points that Medicare is going to be collecting. Medicare wants to know how much how much of the settlement is attributed to that Medicare set aside, and what is being set aside, how long that MSA was intended to be funded for, typically the life expectancy of the individual, whether or not that MSA was funded as a lump sum or an annuity, and if it's an annuity, what that initial seed or deposit amount is, as well as what the annual payment amount of that annuity payment would be. Now, those are mandatory. There are two other optional fields. We hope that Medicare will continue to consider these as optional, but first is that case control number, which is assigned if an MSA is submitted to CMS for review and approval. And then the other one is the professional administrator EIN number if it's being professionally administered. Now, a couple of things to remember and to understand as key points related to this reporting I mentioned previously. This requirement applies to all workers' compensation settlements involving a Medicare beneficiary. So those that are familiar with the MSA submission process may ask yourselves, well, what if it doesn't meet the CMS review thresholds? Well, the answer is that MSA or that MSA data still needs to be reported to Medicare, whether it's over $25K for a Medicare beneficiary or under threshold for review and approval by CMS. Also, if there is no MSA that is allocated as part of the settlement, then you still need to report that information to Medicare. You're essentially reporting $0 to Medicare for that Medicare set aside. And again, Medicare will be monitoring this, taking a look at this, and if they so choose to audit and look more closely into it, they may very well ask additional questions. And one thing they did point out that they were especially sensitive to are these settlements that are reporting $0 to Medicare, where there's a substantial settlement amount that may be attributed to it. They're going to question whether or not there's truly no future medical associated with that particular claim. So something to keep in mind as you kind of evaluate this requirement, as you participate in submitting this information to Medicare, and also thinking about your MSA program in relation to this. All right, next slide, please. So we do see that Medicare is doing a couple things with this data. We know that Medicare is flagging what we call the Medicare Common Working File when a Medicare set-aside is reported through Section 111 reporting to Medicare, and they're marking that Common Working File to let providers know there's an MSA to pay primary, and therefore Medicare will deny payment for treatment associated with that claim until that MSA is fully and properly exhausted. We have also seen that where there's a discrepancy between the reported data through Section 111 reporting and the MSA submission process, that it could impact the approval that might have been issued. So by way of example, let's say I submit an MSA for $30,000, Medicare approves it, but I accidentally report $3,000, right? Because of the because I've just failed to input that extra zero. Well, Medicare is going to look at that $3,000 report through Section 111 reporting. They're going to look at the MSA approval for $30,000, and essentially they're going to say, well, because those values do not match, we are going to say that the approval that we previously issued is no longer applicable. You are essentially settled with a non-approved MSA value. So it's very important that that data is reported accurately. Otherwise, again, it does have downstream impact. All right, next slide, please. So a couple things that we've observed since Medicare has rolled out this requirement. No surprise here. We've seen some data challenges. Claims handlers are probably not used to having to report this data or even understand some of the requirements or requests behind it. How do you calculate out the MSA period, for example, right? If you don't have a formal MSA calculated. So some things like that have proved to be challenges here. We also see, and that kind of leads to some of the data mismatches that may have occurred. We also see a significant number of zero MSAs submitted, largely because they were under threshold, sometimes when they're over threshold. But again, Medicare will be receiving this data, so they will have insight into settlements that don't include a Medicare set-aside. And again, as I mentioned in the previous slide, we've seen how Medicare has utilized this data to impact the coordination of benefits, as well as the submission and approvals that are on file involving a Medicare set-aside. Some things that we're keeping an eye on. Go ahead, Mark.
Oh, I'm sorry, Sid. No, go right ahead. I'm sorry.
I was going to say some things that we're keeping an eye on for 2026 are listed on the screen here. I'm not going to go through all of it in a lot of detail, but we want to see, Medicare fix some of those kind of data issues where applicable. We want to see if Medicare reschedules that webinar, and a lot of different things that we'll keep an eye on in 2026. Thank you. Next slide.
Sorry about that, Sid.
Yeah,
Sorry.
no problem. No problem.
I was getting all excited.
All right. Yeah, no, I know. This is exciting stuff. So I'm going to turn back over to Mark, and we can talk about, the recent changes for how Medicare is treating $0 MSAs in the submission process. Go ahead, Mark.
Yeah, thanks, Sid. Yeah, it's sad that I'm excited about it that much. But the point is, and those of you who are involved in the workers' comp space, we know that sometimes in our cases, we're going to settle, but we believe we should have a zero MSA. There could be a medical reason for it. The guy stopped treating, doesn't need any more treatment. Why should we allocate money for the future? Or we could have a legal basis. We denied the case from day one on whatever legal ground we have. We're settling just to buy our peace. So we shouldn't have to allocate money for a Medicare set-aside in that instance. Now, traditionally over the years, if you met CMS's review thresholds, you could submit a zero MSA to CMS for their review and approval. It was a torturous experience. They generally didn't like to approve them. They find any particular weird reason to reject your zero MSA, typically based on stuff that had zero to do with workers' compensation law or concepts in the country for the past 100 years. Okay, so for many, the good news this year was that as of July 17, 2025, not sure what the magic is of the 17th, but as of July 17, 2025, CMS no longer reviews zero MSAs. Now, can you still have them? Yes. What you need to do, you see it there at a glance, is you need to, go to the reference guide, the MSA reference guide, section 4.2. Within 4.2, CMS outlines the criteria where they would feel a zero MSA is applicable. And if you think, remember, it's a Home Depot situation here, it's a do-it-yourself situation, okay? If you feel that the facts of your case meet that criteria, then you'll proceed with a zero MSA. CMS doesn't want to see it. And then, most importantly, you must document your file as to the reasons why you decided to go the zero MSA route. And Sid brought up a very good point. Some of these cases are going to have to be reported through TPOC MSA. And if you throw down a 0, like Sid said, they may have questions about it. They may audit it. And you need to have the documentation in your file as to why you decided to go with the 0 MSA. So how does it look, like practically after today? So basically what the screen is saying is pretty much what I told you. As of 17th of July, CMS no longer wants to see these 0 MSAs. You can still do them. And what you'll need to do is bring your facts to each one of these columns here in the purple and see whether the facts that you have fit into any one of these conditions, criteria. If so, then a 0 MSA would be applicable. You would document your file, keep that in the file, and move on with your life. There could be a medical basis. The doctor indicates the claimant no longer needs further treatment. There could be a situation where you've denied the case. You haven't made payments outside of investigatory type payments. You're not providing future medicals as part of the settlement. You may be able to fit your facts in that column. Or you may have a court order on the merits. You went to trial and the judge says you're no longer responsible for X, or you never were responsible for X. Court order on the merits. That could give you a basis for a 0. Likewise, maybe you just made payments as part of a pay and investigate statute, the 90-day, 10K thing out in California, the 120-day rule in Florida, for example. Well, maybe you fit the facts and the criteria of that CMS column there. And if so, then you would be eligible or appropriate for a 0 MSA. You would document the file and move on. Okay, so you can't go willy-nilly. You got to come here, pull up 4.2, call me or Sid. Okay, let's figure out whether you feel comfortable, as it's now a do-it-yourself situation. The other big one, and this is a positive one, okay, amended review. This is the situation where, let's do it by example. You submit an MSA to CMS, I don't know, let's make it up, $80,000. They blow it up. They give you a counter hire approval of $120,000. That kills your settlement. You keep the case open. Case drags on, but conditions change. The claimant's medical picture has changed drastically, significantly, where you feel you now have the basis to go back to CMS with a new MSA to say, look, man, 120 was, crazy to begin with. But, the facts have changed so much here. The plaintiff's off that expensive drug. The claimant had the surgery. The claimant had the implant, et cetera. So, yeah, we initially came to you with an $80,000 MSA. You jacked it up to $120,000. We now believe the true MSA should be $38,000. And you do that by a process called amended review. It gives you a second bite at the apple if you meet the criteria on the left. You can only do it once. So you got to know when to go. You better have the right medical evidence. And the big change this year is CMS used to have a 1-year waiting period. You would have to wait 1 year from when CMS gave that initial approval that destroyed your settlement. Okay, right? And now you don't have to wait that 1 year. But remember, you still got to be ready to go. You got to have the right medical evidence, right? You want to maximize your opportunity. Case still needs to be open, and you're looking at pitching a reduction of at least $10,000 or 10% of what CMS initially approved. This is good. Amended review is good, and they keep tweaking it every year to make it better. Okay, so really what you want to think about when you think about amended review is you want to think about a file that's still open because there was a high CMS approval, circumstances have changed, you think now the MSA should be even lower than what CMS had approved. Amended review may be the way to go. Submit a second MSA. Work with your MSA expert to determine the best time to do it, because you only have one shot to do it on that file, so you better have the right evidence. Other MSA updates, Sid. You wrote a great article on fiscal MSA stats. Tell us about it.
Yeah, so this was just recently released. This is something that Medicare provides every year for the past couple of years now. It just gives high-level data and statistics around their MSA submission and approval process. There's not a lot of information that can be gleaned from this, but what I can tell you is that if you look and compare the number of MSAs that they have reviewed this year, it has actually decreased about 1,000 cases. So if you look at kind of maybe, you know, some of the influencer or events that may have impacted this, you know, I can say that, you know, workers' compensation claim volume is down, so they may have, you know, the decrease in approvals may be attributed to that. We also do see workers' compensation, and not just workers' comp, I mean, across, I think, all lines of, you know, coverage lines, is the claim severity has increased. So we are seeing, as part of these statistics, that the submitted estimated total settlement amount has increased from the prior year. We also know, as Mark indicated previously, that Medicare has sunset their review of $0 MSA submissions as of July 17th of this year, and that likely has impact on the number of submission approvals that Medicare has issued as well. Finally, we know that the industry has leveraged non-submission and or what we call evidence-based Medicare set-asides to settle claims, and that may be increasing. And certainly if it is, that does have an impact on the number of MSAs that CMS would review. And then finally, with the new reporting requirements, submitting MSA data to CMS, there may be some consideration around whether or not submitting an MSA to CMS is duplicative, right? Because Medicare is going to have this data both ways. So why not just submit the information through Section 111 and not have to worry about the submission process? Now, we obviously still feel like there's value in getting CMS to approve a Medicare set aside, to certify that value, to know that with certainty post settlement that there's not going to be any issues of, you know, treatment denial, as long as the MSA is properly utilized and exhausted. But again, thinking about just kind of all potential factors of those numbers, that, you know, those are some of the consideration points. All right. The other thing that Medicare recently released was a notification or notice that they will be passing Medicare set-aside data to Medicare Part D plans starting February 2026. Now, what this means is that Medicare will pass what we call national drug codes, or NDC codes, to these Part D plans, so they're better able to identify where there's a Medicare set aside that it includes medications, and those types of medications that are contemplated or part of that claim, the underlying workers' compensation claim, and that MSA. So if there is something that relates to that NDC code, that the payment of that through the Medicare Part D plan would be denied. Typically, this is likely going to happen at the point of sale. So, you know, something that will certainly assist these Part D plans with coordinating benefits, but also, you know, our concern is it does have impact on these beneficiaries, right? We certainly don't want to see beneficiaries unnecessarily have their prescriptions denied for payment, making sure that they're able to still get that. And with anything involving, you know, CMS and the rollout of these new, you know, kind of like handling and policies, to ensure or implore CMS to ensure that the beneficiaries are not negatively impacted unnecessarily, right? So something we'll keep an eye on, and hopefully, you know, it's going to work as intended. But again, you know, we just want to make sure that beneficiaries are not harmed unnecessarily. The other question is whether or not you know, this is going to lead to more active Part D recovery, something that we'll continue to monitor as well. But the key takeaway here for Medicare secondary payer, for compliance, is that it does not change what we're reporting to Medicare as part of Section 111 reporting. It does not change how we submit or what we're submitting to CMS as part of that MSA voluntary submission process. All right, next slide, Mark.
Yeah.
All right, so I'm going to turn it back over to you now, yeah, to walk us through some of the liens.
Yeah, and then Sid and I joked that if we thought we have to talk about Part D, you know, at the beginning of the year, we both would have put that bet down in Las Vegas. We probably would have.
Yeah, it was not on my bingo card, right? Yeah,
was definitely not Sid. So that was a late addition to our session, courtesy of CMS. So let me rattle off a few quick ones, and then we'll take Q&A. So Medicare liens, conditional payments, really not a lot of action going on there this year. And look, CMS continues to aggressively pursue their liens for Part A and B claims. Medicare Part C continues the Medicare Advantage plans, those private plans. They continue to pursue their liens, and in some instances, lawsuits for double damages. Part D still lagging behind. Maybe that changes based on what Sid talked about, but really no major like policy changes. Okay, but significantly, recovery activity still goes on. What I always like to do as part of these sort of mop up year-end type of things is show where we are with the question of which jurisdictions are allowing Medicare Advantage people to sue for double damages. Look, CMS can sue an insurer for double damage. There's no question about that, okay? And it's pretty clear in the statute. For reasons we won't bore you with, whether a Medicare Advantage plan can also sue for double damages, it has been a litigated point, but more and more courts are saying yes. The Medicare Advantage people can sue for double damages. The states in red are U.S. Court of Appeals, Circuit Courts of Appeals. Florida, down there in the South, it's 11th Circuit, Mid-Atlantic, it's the 3rd, and then sort of the Northeast, it's the 2nd. So these circuits have all ruled that, yes, Medicare Advantage people can sue insurers for double damages. So you're litigating those states, you got to take it seriously. If you're in the other states, a little bit of caution. It's, these are lower level federal courts, U.S. district courts. It's just a caution. Be careful. These jurisdictions have lower court, U.S. district court authority. Texas has 3 different circuit courts. California, I think it's really been the central district for 2 or 3 cases that have allowed the Medicare Advantage people to sue for double damages. If you're in the gray states, that just means the courts haven't addressed whether or not these Medicare Advantage people have double damage rights. However, remember, they would still have some form of lien rights, so you just can't blow it off. Maryland, feast your eyes on Maryland. A case we're watching in 2026 is this one. There's a case percolating in the federal court of Maryland for double damages. There was an initial question about whether the Medicare Advantage people could bring the suit in that case because they were using an assignee, a third party, to do it. Long story short, the Maryland Supreme Court weighed in and said, yeah, that's not a problem. They could use an assignee to bring their suit. So the case now goes back to the federal court, and we will wait to see what happens there. Will Maryland have an award of double damages in 2026? We will see. Liability MSAs. All quiet on the Western Front. A lot of action in workers' comp MSAs. Got to war sit out this year. I mean, it's all he was doing, okay, with this TPOC MSA stuff. But as active as CMS has been on the workers' comp side, thankfully, maybe, right? They have really been inactive on liability MSAs, and that's probably a good thing, right? Okay, long story short, what the slide tells you is this. They've made 2 serious attempts at establishing formal liability MSA regulations. They abandoned their attempts both times. The last time they abandoned it was in October 2022. We haven't heard anything from them since at the CMS that they're ready to revisit them. Sid and I don't see anything on the horizon right now. So as we sit here, all quiet on the Western Front, we will continue to monitor things for you. In Washington, the RAMP Act was reintroduced. That would eliminate the double damages provision that I just talked about. We'll keep our eyes on that. This is the 3rd time it's been introduced over the years into Congress. We'll keep our eyes. Washington's a wild place these days. Sid and I had to deal with that shutdown for 2 months. It's wild times up there. Okay, Diane and Cece, that brings us right on the mark here to some questions. Okay, and before we go to the questions, I do want to say one thing as part of your compliance considerations on the liens. Okay, and I forgot to mention this before, but it's very important in 2026. Remember, when you deal with Medicare liens or Medicare conditional payment claims, your processes and protocols really need to understand and contemplate the fact that there could be different ones, right? There could be A and B, and you deal with CMS. It could be Medicare Advantage C, and you have to deal with the Medicare Advantage plan. Or you could have a prescription drug plan involved, and you have to deal with the plan. So a lot of times, Sid and I see mistakes being made where parties will go to CMS and say, hey, man, you got a lien? And CMS will come back and say it's 0. Well, guess what? The person was on Medicare Advantage. And CMS is not going to have that lien information. You need to know which Medicare Advantage plan it is and then go to that plan. Now, what could help you there is the CMS Section 111 query process. The 111 query will return to you not just whether or not the person's on Medicare, but if the person is on Medicare, it's going to tell you the type of plan he or she is on. A and B, government; C, Medicare Advantage; and or D, drugs. So that's where you want to look. You're not going to get the lien information from the query. Okay, don't make that mistake. But you're going to get the information from the query, which will then allow you to go to the proper entity to get the lien information. So that's very, very important. Okay, sorry I missed that in the case in chief. Diane, Cece, we're ready for questions.
Cece, are you there? Well, she doesn't seem to be there. So let's see.
I hope we didn't put her to sleep, Diane. I'm
certain you didn't. She works with you and is always, you know, energized by you guys' energy, of course.
Right.
All right, let's see here. So I don't have my glasses on, so it's going to be a little tough. Sid, can you see the questions?
I can. I've actually been monitoring the chat. I don't see any additional questions.
No, it's under questions. This is if we have done a WCMSA and the medication is covered and we have CMS approval, once we settle via CNR, can they come back for reimbursement even after we have included the medication in the MSA/CNR?
Yep. So per CMS's guidelines, if it was not fully funded, then no. I'm sorry. If per CMS's guidelines, if the MSA was fully funded, then no, CMS cannot come back for reimbursement against the carrier insured.
Got it. All right. Let's see. I see thank yous here. So what is TPOC? I'm looking at materials, and so if I missed it, they'd like to know what it is.
Oh, yeah, sure.
I got it. I already responded in the chat, but TPOC stands for total payment obligation of the claimant. It essentially represents a settlement of the claim which resolves or has the effect of resolving the medical treatment for the claim.
Got it. All right. Well, I don't see any other questions. Oh, there's Titsi. Hi, Titsi. How are you? She's waving. All right. Very good. Well, is there any last words that you would like to leave for our audience today?
No, I'd just like to thank everybody for attending. I know you guys are busy. It's the end of the year. Hopefully you're out there settling cases. And Diane, thanks for inviting us. And Sid, as always, great working with you on this.
Appreciate it. And certainly if there's ever, any other questions or if you need assistance with Medicare secondary payer compliance, don't hesitate to reach out to either Mark or I. We're always here to help.
And if you ever want to see this presentation again, because it was chock full of lots of information, you want to say, what did they say about that? You can go to the Macro Pro YouTube channel and you can find them there as the third CEU for 2026 as 12 CEUs at Christmas. All right, so just a couple reminders. This afternoon, we're going to have a masterclass on the DIR website. So if you want to figure out how to navigate that, be sure to watch that today. Chris Bowen's going to be sharing that information with us. We also have some personal growth items this year, including one, it's called GLOW. It's a framework of personal empowerment and sustaining growth, which is really great to keep us, we work so hard and our jobs are so taxing that it's really great when we can learn something to take care of ourselves. Here's one that's worth the money. If you have not registered for this, I beg you to do so because I think it's going to be something that's going to be very, very helpful to anyone in claims. It's called Keeping Calm in Claims, Managing Your Stress and Your Claimants. Let's face it, life is really, really stressful. So if we've got somebody as renowned as Carl Van that is going to walk us through that, I think that's the class that we should definitely be watching. And I believe that's on Friday. And then we have Leslie Dilbeck that's going to be talking about unwrapping layers of medical reports. And it's an epic exploration with her. So be sure to join us for all of those. We want to thank you very much for joining us here at the Macro Pro and Friends webinar. Bye-bye now. Thanks again. Appreciate you guys being here. As always, gentlemen, great job.
Thank you, Diane.